creditor versus debtor. All right. So let's get a little bit refreshment. Give me an example. Okay. What kind of relationship could be between what kind of relationship you will find creditor and debtor? Give me an example. A lot of combination. Anything can make you think about creditor versus debtor, and then we will give you the example. We'll follow out the example. What? Yes. How about more usual? That's a very special case. How about let me give you one example. Say buyer seller. How about that? Right? Give me the more usual, more simple. Simple.
Go to the bank and ask for a loan.
Okay. Yes. Bank and borrow. How about that? Lender borrow. How about that? Think about this.
Credit card user.
Yeah, good. Probably like you, right? You use credit card, so you are the borrower, and credit card company is the creditor. What else? What else could be? A lot. Let me tell you. We have a bank, borrow. We have a seller, buyer. We have a credit card user. We have the credit card company. Anything can make you think about creditor versus debtor. That's all? Just three? Must be more than three in our daily life, right? How about student versus a school? Right? If you don't pay tuition, you become a debtor. Right? A lot of combination. If you are the patient, you go to a hospital, you don't pay the bill, and hospital become the creditor, and you become the debtor, right? Anything. So even though today we only use a very abstract terminology here, creditor versus debtor, but in our daily life, it may apply to a lot of situations. Tong is here. So some.
Kids.
Yeah. Maybe here. Okay. Tong is here. So probably for the majority of you, you have not done your homework yet, but this is related to your homework. So let's return back to the situation, okay? Let's focus on the seller buyer. Say, your company just sold a merchandise to somebody else, and that is your homework. I have a few students already turning in. For the majority, not done yet, that is the situation, okay? So for your homework, you just make out your own story. You are the seller, and you sold one merchandise to your buyer, but the payment is like 30 days, 45 days. In order to secure your right, to secure your more possibility to collect the debt, so you file financing statement to the state, right? So here is one kind of creditor versus debtor. So let me ask you, okay, why, as a seller, you want to file financing statement? What's the benefit? What is the benefit to file financing statement with the state? What is the benefit?
To have the public record.
Number one, to have the public record, that really means you announce this situation to the whole world, right? Even though you transfer the position from your warehouse to your buyer, they are in the control position right now. However, you still keep the right. In case they don't pay you, you can get it back. Or if the buyer, without paying you anything, before you release such claim, if they sold to any third party, doesn't matter how long, how far away the same merchandise transfer out to, you still can claim. So one of the benefits you file with the state is you more like pronounce this ownership right to the whole world. More like you purchase automobile, get a loan, right? On the pink slip, always indicate who is the lender, right? Who is the lien holder. So they really mean the debtor, before debtor pay off everything, they cannot resell to anybody else, right? So, yes, one of the benefits is, you want to prolong this situation to the whole world. And if any third party say, well, I'm not aware of the situation, and the law protect you, not the third party. Because once you properly file, okay, with the state, nobody can say, excuse me, I'm not aware. So in the legal terminology, okay, we have the actual knowledge, knowledge is something sometimes we say notice, okay, versus constructed notice. Okay, this is the one terminology you may consider to take away with you, okay, today. We say constructive notice. They really mean somebody filed the document with the state. Like if you own a real estate property, you file this situation with the county. So nobody can say, I don't know, because once you file with the government, it becomes constructive notice to everybody. All right. So just as Ivy mentioned, one of the benefits to file the financing statement is to pronounce you keep certain right on certain merchandise. So that is very important, right? So I just want to remind you, when you do your homework today, because it's still next Sunday, there's big blank space there. It's a financing statement. You need to fill it in very specifically, okay? You need to fill in the item, better off with the serial number, description, the quantity, and the unit price, right? You need to put very, very specific. Otherwise, you cannot protect yourself, all right? So better off you indicate what is ID, mean serial number or description. More specific is better for you, all right? All right, so I think it will only take you about 5 minutes to fill it in, learn how to fill it. However, I think hopefully that will be very practical and helpful for you in the future. Okay. So Christine Maria is here. Okay. Oh, by the way, for those of you who came in late, please write it down. Those 3 days left, especially for the last day, I changed it. Sorry about that. Usually I will keep the same schedule, but however, sometimes I have another event coming up. So I changed the last day of this course from May 4th to 1 week back. So the last day is May 11th. All right. Anyway, so let's continue our topic for today. Creditor versus debtor, all right? And for next session, okay, it's 2 weeks from today, April 6th, you have 30 minutes in class midterm, and the exam is from your book. Okay, let me just give you a little bit tip, okay? So if you don't get a book, I cannot help you. So please get a book as soon as possible. It's very, very simple questions, and I will cite you case. It's a true case, all right? It's a real case, and that related to the topic today. It's related as a creditor debtor case, and there's one real case. Okay, a lady filed a lawsuit against one party, all right, and claimed recovery, monetary damages recovery, and there's argument, and how to argue, okay, that is the standard. Okay, that's called standard. And I understand you only have 30 minutes to answer the whole thing, right? So I pick out a very simple case. There are only two standards to make argument, all right? Only two statements to make the argument. So you just follow out those two standards there. So that's why you need a book. Okay, I will not give you the detail on my exam. I say refer to the book, okay, and that is the case. Huh? Of course, it's open book. So that's why I say you need to get a book, all right? That is a privilege, okay? Open book is open book, okay? But not open mouth, okay? Just open book, all right? So only two standard. You need to follow the standard, all right? But sorry about that. You don't have such freedom to argue. I designate the party to you. So do not argue for the wrong party, okay? Making sure, number one, you follow out two standards, right? You cannot just write whatever you want, okay? You need to follow out those two standards cited by the, or used by the court, okay? So you need to follow those two specific standards. So you need to use the standards. Number two, you cannot argue as your wish. I already designate to you, I say you argue for plaintiff or you argue for the defendant, all right? And I already designate. So you only argue for the right party. Okay, so you read the case briefly and you read through those two standards and then you argue for the right party. Then you just give me the reason why the party you represent to should win the case. All right? So I think it's a lot of fun there, right? And then I will not teach you for today. I will on purposely I will miss the case. Okay, I will not cover in our lecture today, but I just give you a hint, right? It's covered in today's topic, generally speaking. Okay, let's go back to our situation. Your company sold the merchandise to the buyer. If, okay, big if, hopefully it will not happen. If the payment past due, payment past due, how should you do? Before we get into the detail involved the creditor debitor issue. So right now, the thing happened, okay? On a certain day, payment past due. Let's leave it alone, litigation at this moment, okay? So do not give me the answer, say we filed a lawsuit, okay? Because it is very expensive to file a lawsuit. To run your business, to run your regular daily business, you will try to stay away from litigation, all right? Even though I know that's a very easy answer for you, okay? So in real life, when payment past due, as a businessman, as a businesswoman, how should you do? Yes, Marie?
In real life, it's a common practice to send them a notice, give them at least 30 days to respond. If they don't, then you take legal action of that.
Okay, give us the notice. Anybody have the input to this response? Anybody? Send out the notice? I will agree with, but I think 30 days is too long. So how about, let's talk about this. If you were in this situation, you try to collect the overpass due debt, how many days you would like to give up?
Well, usually in court, they give you like 30-day notice, but then as a courtesy to whoever you're doing business with, you give them a call.
Give them a call first, definitely, right? You do whatever the best you can do. You just try to find out the person. But let's get the situation more in the real life. What is the wording? What is the sign? Does not look very good. What is a red flag? What kind of thing make you feel not comfortable?
No response.
No response. Phone cut off, and the mail returned to you.
Or the business is closed.
Right, the door closed. Right? So that is not good sign. And also another bad side is the check bounce. Check bounce. That's even worse because you will be charged by the bank. So you need to get alert, something is not really good. So in real life, as I say, unless you are in retail business, okay, because for this issue is big issue. We follow up the topic from last week, right? I think the payment issue for this course, okay, business law, I think doesn't matter what kind of business model you are running. I always think the payment is always the center issue. Okay, you may not be, really agree with me because for the high tech, probably R&D is the major thing, because a lot of startup company, for the first few years you don't have any payment issue, right? For the high tech company, typically in Silicon Valley, startup company they don't care about the payment issue because for the first 3 to 5 years, you only care about the money coming in from the right from capital investor, from angel, from whatsoever, from bank, from investor. You don't care about the product. You only care about the money coming in. However, in order to run the real business, I think payment issue becomes the center issue, right? So once the payment becomes overpass due, then you make a phone call, you try to send out the notice, and then if still cannot collect it, how should you do?
Send it back to the collector agency.
Okay, let's talk about this. How about collect agency? Anybody use collect agency ever? Yes. What is your feeling? What is your experience? Can you share your experience with our classmate? I used it before, but it's a headache. But anyway, still.
Well, first of all, they know the law very well.
I will talk about that.
Yeah, so they follow all the procedures.
Steps, right?
Steps.
Okay.
And then, but the thing that they did is, there are 2 ways of charge people. One is,
How do they charge?
yeah,
How?
they either charge in front or they charge it on the collect part.
Okay, let's stop here. Okay, if you consider collect agent, okay, or collect agency, and number one, they must follow a very very strict law. It's called I done this a few years ago. It's called FDCPA, all right? Federal, I'm sorry, Fair, F-A-I-R, Fair Debt Collection Practice Act. If you check Google, you type FDCPA, come out. It's a federal law. It's very very strict to regulate how collect agency can do. And in the United States, I think we are really benefit from this law. In Asian country, you can imagine, right? You can get members to come out to knock on the door, and you don't pay it, you've been taken away, and probably you just disappear somewhere. All right, that is what happened in another country. But in the United States, debtor was protected under this federal law, as Stephen just mentioned. If you use collect agency, they may tell you, okay, there are certain things we cannot do. We cannot knock on the door. We cannot. We can only make a phone call and during the specific business hour. And we can only send out the bill, just as Maria just mentioned. We can only make the phone call, contact, and also send out the mail. Even on the phone call, on the mail, collect agency must put a warning, say this is collection. This is collection. Okay, you have such a right to refuse. So, well, a lot of very very strict regulation. Okay, but after this lecture, okay, I do not mean to teach you how to go around the debt you owe to somebody else. Okay, as I said, as a debtor in the United States, we are really protected under this law. All right. I think really, people in this country, they got financial hardship, and the society and the legal system try to give them opportunity to reinstate, to get back on their foot. But this is the situation. And also, as Stephen just mentioned, not only for the procedure, but also for the fee. Think about this. If you were the creditor and somebody owe you money, and you hire the third party to collect it, if the third party told you you need to pay me some certain amount of money up front in order for me to do the job for you, what is your feeling?
Put the good money in the bank.
Yeah, you put good money in, you put a lot more good money after the bad, right? After the for the bad money. So probably for the option 1 you will say no, and for the option 2, probably more commonly is option 2. You enter into the agreement, okay? You say whatever the money you collected, we share. So Stephen, remember what's the percentage roughly?
Well, it really depends on the case. The case I have is like 20,
25. You mean the agency keep 20%? You keep 80%. That's a very good deal. That's a good deal. Usually it's 50-50, let me tell you. And a lot of factor to determine the percentage. There's no fixed number. So for example, where the debtor is, or what kind of business the debtor is. If it still is ongoing business, is retail business, and is the local business, is easier. All right, it's easier and depends on the amount. Yes, Maria.
If the person, individual or a business does not, if you don't get the money, you file it with the small claims court.
Yes.
You're able to collect whatever the third party charges you.
Yes.
Along.
Yes. Yes. So we mentioned small claim court in the first class, right? If the amount is under $10,000, then don't bother. You just go to the local small claim court, and it should be very easy to get the money back. But right now we're talking about probably, huge money, the business transaction. We don't know. Hopefully it will not happen. But call agency is not, it's not the best way, but it's something you may need to consider. Okay, at least you may need to consider it. Yeah. If the money cannot be collected. Oh, by the way, if you are in the debtor position and someone call you, say, they represent the creditor, you don't freak out, okay? You don't freak out because you have the law protect you, right? And if you cannot pay it, if you really beyond your financial ability, you can just avoid it. That is your right. That's the right under the FDCPA. All right. So a lot of people come to ask me, say, if I were in a very bad financial situation, and really, truly, I don't have any financial ability to negotiate, how should I do? I say just avoid it. There's nothing wrong. There's no any legal liability or legal obligation for debtor to come out. Okay, you just say, I cannot do anything. I cannot do anything. All right. However, there is another chance here. There is another chance during this collation process. Okay. Again, I don't mean to teach you, but that is a very common practice. Okay. During this collation period, creditors sometimes come up with very good deal. Come up with very, very good deal. Sometimes it's like 20%, 80% off. Say if the person owes $10,000, they can settle between $1,000 to $2,000. Very, very good deal. But okay, by the way, that's a very ironic, okay? It's very ironic, okay? In the practice, if you still have such financial ability to negotiate, usually you don't owe the money. You pay on time. You understand? If the person still keep such financial ability to do the negotiation, say I can pay 20%, that kind of person usually will not get into this situation. They just pay on time. Alright? And for those people really got deep trouble, even 80% off, they still cannot pay for it. You understand the situation? Very rare case, very certain case, people say, okay, I can pay you 20%, because you don't have such exact level of financial difficulty, right? Say, I'm just in this level, okay, I can pay you 20%, and because usually when people got trouble into the financial difficulty, they don't just owe one bank, they don't just owe one account. Typically for my client, they owe 20 accounts. I say, what? They show me the credit card, spread out the table loan. Say I owe 20 accounts. I say, what happened? For each account, probably just 1,500, 2,000, small amount, but they don't owe just one account. So it's really ironical. Even you got a deal, you got a very good deal to cut, but it's still beyond your ability. Too late. I mean, it is too late. It is too late.
Well, I'm in business, for instance, and I want to go after that person or business. How am I going to go get my money back?
Yes, I will go step by step. Yeah, still right now in this classroom, I may switch my position back and forth. Sometimes I will tell you how a debtor can try to avoid the ability, but I think the main thing is I will tell you how to collect the money for this class. But I may switch the position back and forth, right?
So for some advertisement that some company can help you to reduce.
Be careful.
Yeah. So what kind of agency is that?
No, that's fraud.
Okay.
That's fraud. Let me repeat IBs, okay? For some people, they really got it into the very deep trouble, right? They all say 20 accounts here, right? And you can see the advertising either on the radio, on the TV, on the magazine, on newspaper, say, we can help you to settle the case. If they are not a lawyer, even they are lawyer, making sure they are local lawyer, right? I think a lot of people, they just, enter into the agreement with this company. It's called settlement company or say debt settlement. But usually 99% they are fraud. They just take the money and do nothing. It's very typical financial scheme on the market, all right? Unless this is a local law firm, and you can hold his or her license as a liability. Otherwise, for this kind of company, they just take money and do nothing. Okay, they say, okay, $10,000 step. Okay, we enter into the agreement. We will represent you to negotiate with your creditor, and then our target is we settle at certain amount of money, but it never happen. It will never happen. Okay, it's not true. Okay, so making sure if your friend or some people they have such situation, be careful. Okay, if you really want to pick up the company to negotiate, making sure number one, better off it is lawyer, and number two is local, and they have a physical office there. Okay, usually, trust me, 99% they are online. They just make a 800 phone call, and you never know where they are. You never, even somebody answer the phone call, but you cannot hold them liable for your case. So be really careful about that, all right? But discount is real. Discount is real, okay? During this procedure, and either sent by the original creditor or sent by the court agency, in the mail, say, in order to settle your case, then we offer you this amount, but there is expiration date. If you want to take it, this is it. Okay, even with in that situation, better off consult with a lawyer, making sure that's real, because a lot of skin on the market, a lot of, just be careful. Okay, so let's go back to Maria's situation. You are so anxious to collect your debt because you are the creditor, you are not the debtor. You are the creditor. You are so anxious to get the money back. So you can skip the collection process. Don't waste your time. By the way, let me tell you what, okay? There is statute of limitation. Be careful. Statute of limitation. And also, flip the other side. There's a protection for the debtor. Alright? That is another protection, legal protection. Statute of limitation. Anybody know what's this? What is a statute of limitation?
It's a certain, I guess, call it like expiration when it starts, for instance. I mean, I filed something with the court.
Close
And-
enough, right? This is more like expiration day and determined by law. Okay, let me give you one example, more concrete. Okay, say for example, in this situation, you ship out the merchandise to the buyer without financing statement. Very bad. But usually, in our real life, we don't file financing statement. We just expect buyer will pay on time. Say for example, the due date is February 28th, the end of February month. Okay, say 2013, and you have everything in written. This is the written contract, all right? And then the due date is May 28th, 2013. But the payment did not come through, and or the check bounced whatsoever, right? Then you start to collect the money, make a phone call. By the way, you can knock on the door, okay? You can knock on the door just without any unlawful forces, okay? You can just go there to visit him, very friendly to find out the situation. That's okay. That's fine, all right? However, if you do not file the lawsuit with the court, all right? I mean regular court, superior court, okay? Within 4 years. So this is 14, 15, 16, 17. So if you did not file the lawsuit by February 27, 2017, 4 years after, it's gone. It's gone. If filed the lawsuit after 4 years, debtor just filed a motion to the court without any other reason, as the defense say it is beyond statute of limitation. The case dismissed. The case dropped.
It's all different, right? I mean, in California, you said before it was just 1 year.
1 year is a small claim court, so it really depends on which court you go to. Very good questions. If this is under $10,000, everybody follow me? If this is under $10,000, by the way, even under $10,000, you still can consider file the lawsuit with superior court. All right? So even the amount is under $10,000, after 1 year, you cannot file anymore with small claim court. But still, you have another 3 years, you can consider to file with the regular superior court. However, it's more expensive. Usually the procedure is very complicated. All right? So small claim court is the best. It's the best foreign you can consider to go, but keep 1 year. Okay, you have 1 year. All right? So making sure you want to keep this statute of limitation. 4 years is a long way to go, but it passed very quick. And last week there was one very poor lady, okay, come to see me, and he was involved a skin few years ago, and that person, took away almost like $800,000 US dollar from her. Not one time, 10 times. So I just cannot imagine how could that happen. Just take the money one time, second time, 3 times, and then finally this lady found out that's a scam. $800,000 has been taken away. And that was almost like 15 years ago. Okay, if that is a fraud, the limitation may be longer. That's another way to calculate, the fraud, okay, because it's 3 years. It's 3 years from the time the victim found out that is fraud. So this lady can argue, I just trust this person. I never thought this is a fraud. I just thought, everything is real, but I found out this, say, last year. So that is 3 years from the day the victim eventually found out, or could have found out. So, defendant may argue, even though you found out, but you could have any opportunity to find out earlier. So the time expired already. But anyway, I don't want to get involved too much.
4 years from the overdue date.
No, here. 4 years is the written contract from the day the contract was breached. So in this situation,
That's only overdue date.
right? Because that's the day the contract was breached, right?
For 3 years, no really firm date at all.
Right, because that's for the fraud. So fraud could be forever. Because the victim can always argue, say, I never know this is a fraud.
Breach of contract.
No, this is different. Breach contract and fraud is different with a cause of action. I'm talking about here, leave alone fraud, okay, because that's too complicated, okay. We don't compare the fraud to this, okay. I don't try to compare what is 3 years, what is 4 years. So forget 3 years, okay. Erase that, okay. Let's focus on 4 years, because for this case, it's from the day the payment overdue. Because that is the day, the contract was breached. So for the breach contract, written contract is 4 years. All right. So here, finally, you need to consider file the lawsuit. However, in order to secure your lawsuit, you need to find out certain item there. So before we consider to file the lawsuit, doesn't matter small claim court or regular Supreme Court. What kind of situation you want to find out to make sure the lawsuit you're gonna fight is good. Otherwise, you waste your time, you waste your money.
The debtor is not.
Again, you put a good money for the bad.
Debtor is not bankruptcy.
Yes, you need to make sure the debtor is not in the bankruptcy. BK is the big issue. I will leave there a little bit, okay. So number one, you need to find out, whether or not the debtor is in BK, bankruptcy. As I say, I will talk about the bankruptcy a little
They
bit.
still file bankruptcy right
Say that again.
away.
Say that.
Right. If they are not bankruptcy right now, but
They can file bankruptcy later
file
on.
away.
Yes, they can file the bankruptcy later on. So bankruptcy is another consideration, okay, to take into account. All right. So let's leave bankruptcy issue alone. Okay. What else? Before you file the lawsuit, you need to consider what, or you need to do minimum investigation about what. You need to see what.
Take the money.
Yes.
Easily pay.
They have the ability. They have the ability to pay. That really means they have certain assets. If they already run away, then you just say bad luck, right? If they close the door, run away, of course you can file report to FBI. You can file the report to police. But usually, I think it's gone. I don't mean, okay, I never mean debtor has no legal liability. It is a fraud, okay? If they owe money to you and they just close the door and they ran away, it's criminal. It's criminal. However, even you report to FBI, you report to whatsoever, I would say it's bad luck. Usually, the law enforcement, they will not put this financial this financial crime as the top priority. They just give you a case number. This is it. They just give you the case number and the case is there. And then for a few years, then close. All right? So before we consider to file the lawsuit, minimum, you need to find out whether or not they are still locally, right? Number two, if they are locally, whether or not they have the assets. And then the number three is they have not filed a bankruptcy yet, all right? So if everything is there, I don't know any reason why they don't pay you. If they still running the business, they have not filed a bankruptcy, and they still keep the assets, I don't know any reason why they don't pay you unless they try to argue the quality or something wrong you deliver to. So that is not the simple creditor to debtor issue. They become probably the merchandise issue. We are talking about the product warranty. Probably this warranty issue. They just claim, the merchandise you delivered does not meet the standard. All right. So let's assume you pass everything here, and finally you file a lawsuit. If you file the lawsuit with small claim court, it's easier. Okay, I believe I mentioned this, right, in the first class, right? For the case pending at a small claim court, each party cannot retain lawyer. You just go there by yourself. So under $10,000, and also as a plaintiff, you don't file the lawsuit twice, more than twice every year. You just once a while. Okay, it's not routine. So collect agency cannot file the lawsuit at small claim court because that is their routine job. There's no way to keep on the 2 cases every year. All right. So if the case pending with small claim court is easy, and parties just go there, okay, follow the court day, and the judge always say both parties go out there to negotiate and then come back. And then when they come back, the judge will still tell them, I'm not the real judge. Okay, and this is just my service. I'm a lawyer, okay? And this is my community service. And if either one party object this trial, then I will reschedule it. And usually, if I am defendant, I will say I object. Because as a defendant, you would like to delay the case as long as possible, legally, by the way. As a defendant, okay, you try to delay the case as long as possible. So either party say no, then judge must say, okay, we reschedule it. And usually it's about 30 days, 45 days, even 2 months apart. So after 2 months, the party come back again. At that moment, it's a real judge sitting there, okay? And then usually the judge only allow like 10 minutes because a lot of people sitting there and waiting for the trial, okay? So only like 10 minutes. So usually judge asked the plaintiff first, what's the case? How much money you claim? And what is the situation? And do you bring your witness? If there's no witness, do you have any certified written document I can see? And then ask a defendant, what is your response? So after the conversation, oral conversation, then the judge will say, either if this is easy case, the judge will make the decision right away. If judge say I need to consider it, then probably take another 2 or 3 days. If the case, okay, in favor of defendant, mean defendant win the case closed. I believe I told you this, right? Did I? If the judge make the judgment in favor of defendant at small claim court, the case closed. If in favor of plaintiff, they mean plaintiff won the case, defendant can consider to appeal this case to the regular superior court. So trial one more time by another judge.
If the judge favors the defendant, me as the victim, can I appeal? I mean, you're saying
No.
the case is closed. So,
No.
Okay.
Let me repeat, okay?
Yeah.
At small claim court, if the judgment in favor of a defendant, plaintiff cannot appeal. The case closed. You lose. This is it, right? You lose. But if the judgment in favor of plaintiff, then defendant has the second chance. You can elect to say, okay, this is it, I just pay for it. Or you say, no, judge made the wrong decision. As a defendant, I would like to appeal to the regular superior level. And then this is another 3 months, I don't know. I have this case one time before. At the superior court level, each party can consider to retain the lawyer. Well, but it really depends how big the case is, because the maximum amount is like $10,000. Usually, if you want to retain the lawyer there, half day, because even it's 10 minutes hearing, usually the lawyer say I will charge you like minimum 3 hours, because I'm traveling, the waiting time. So probably it's not worth it. Probably, I don't know, probably it's not worth it. Okay, so this is small claim court. If finally plaintiff won the case, so plaintiff received the judgment, right? So the next issue is, once the plaintiff received the judgment, the next issue is enforcement. So it's not easy to collect money. Is really, so try to stay away. So this is why you file the financing statement. Even receive the judgment, and not necessarily guarantee plaintiff will collect the money. Okay, because for a lot of people, we immigrate from another country, especially in Asian country. Our historical impression is the court will press the debtor to pay the money in front of the judge. That is not the case. Okay, the judge will not get involved the enforcement issue. Judge only made a decision. So once the judgment is being issued, then it's totally up to the plaintiff to do whatsoever the collection process within the limit of the legal system. So eventually, after the judgment, the true issue just began. Because even you present the judgment to the debtor, the debtor says, this is it, tough day, I don't have anything. And there are 3 major resources that creditor can go to. Number 1, real estate. If debtor own any real estate, creditor can file the record with the county. It's called abstract of judgment. Abstract judgment. Abstract judgment cannot do anything, But until the moment the debtor consider to transfer the real estate property to third party, cannot do it, because this abstract judgment was stay not on any specific real estate. It's overall, general speaking. Okay, general speaking, under the name, follow the name. So it is not specific. It's not specific lien. It's general lien. So if debtor still own any real estate property, the real estate property will be impacted. All right. So that is number 1. Number 2, any bank account, any checking account, CD, safety box, saving account, or brokerage. Such account could be levied by the creditor. Okay, but the problem is you need to spend the money to do the investigation. Okay, I think in the United States it's not easy. It's not difficult, I'm sorry. It's very easy to get it. All right? So the number 2 is to attach the bank account to levy against on debtor's banking account. The number 3, that is garnishment. Number 3, that is garnishment, mean against the salary of debtor. Okay, so let me repeat that. In order to collect the money, is what we call enforcement. Okay, so by itself, the judgment cannot do nothing, cannot do anything. Okay, in the United States, the court will not guarantee creditor can collect the money. It's totally up to creditor to do it. Usually, this process go through sheriff's office. Usually,
Sheriff's office.
go through sheriff's office. So court will not do it. Okay. Sheriff's office. So abstract judgment recording with the county. Okay, and there are 58 counties in the California. So you think you can imagine it's very costly. Okay, if you want to file totally with each 58 countries. And if you spend like $50 for each country, there's a lot of money just to file the abstract of judgment. So, number one, real estate. Number two, the banking account. Number three, garnishment against the salary.
I was just wondering why only sheriff's office. I mean, can you consider like other local law enforcement?
No, they don't do that.
They don't.
For the debt collection enforcement, the government agency, that is the sheriff office, they will do this for you. Okay. Usually, for each sheriff office, they have a different division. Usually, they are in the criminal, right? But there is one small division. It's called civil division. So you go to the civil division of each sheriff office to ask, how can I do?
So for the abstract, is it just filed for the property located county?
Yes. But probably you don't know where the property located is. If you know, it's better, right? But if you don't know, some people just file for each 58. So in case you have something, you leave out. So
So you take the judgment from the judge and you go file
yes,
again.
there is a form. It's called abstract of judgment,
After
and
that
you take the form from the court and you just go to each county to file. But as Abby
So by
said,
filing that, you can go to the sheriff's office. They
uh,
will do it for you.
abstract judgment is nothing to do with sheriff's office.
So where you need to file the abstract?
Abstract judgment filed with the county
County.
recorder's office. Recorder's office.
To protect yourself.
To make sure the debtor, if debtor own any real estate property within this county, if debtor consider to transfer title, you cannot do it because this lien will stay with the property.
How about bank account? You just go to the bank with your judgment.
Sure.
Go through sheriff office. Sheriff office will deliver the notice of levy to the bank.
So where do you get notice of levy from?
Again, the phone is from the website or from sheriff office, either from website, from court, from.
Is there a fee from?
Yes, always there's fee. Always there's fee. Minimum fee, that's okay. But it's very, very tedious. Very, very tedious. There's no fun. Let me tell you. Okay, I was at one point I was in this business as a corporate counsel for the college agency for a few years, and then I think I will switch. I would rather become the defense lawyer for the debtor. A lot easier to become the defense lawyers because as a college agency lawyers, it's head